Craig.
Good afternoon, colleagues.
Of the Special Committee on the Canadian Mission in Afghanistan, Wednesday, May 12, 2010. I remind everyone again today that we are televised, so please, if you wouldn't mind shutting off your cell phones. We're continuing to study the transfer of Afghan detainees, and as our witness today, we have the Honourable Bill Graham, former Minister of National Defence, 2004 to 2006, and former Minister of Foreign Affairs, 2002-2004. Mr. Graham has had a long, distinguished parliamentary career here, and we do welcome you back to this place and specifically to this committee room. We look forward to what you have to say for us. You've appeared before many committees before. Not much has changed as far as how committees are run over the years. We look forward to your comments, and then we would go into the second round of testimony. So thank you for appearing, and we wait for your comments.
Well, thank you very much, Mr. Chairman, and thank to the committee for inviting me to speak to you this afternoon about this important issue. And I just want to say at the outset I wish the committee well in dealing with an issue which I think is very important, not only for the future of the Canadian forces, but for the way in which we will be able to deploy them in future actions, which I'm sure they'll be called upon to serve for Canada as they have so well in the past. I think I can only be helpful to the committee, and je m'excuse du fait que je vais parler.
And I apologize for the fact that I will be speaking largely in English. But of course, I am prepared to take questions in English afterwards.
Just outline a few observations of my own at the opening, because I believe at this point I could perhaps be helpful to the committee in understanding the circumstances around which the original agreement was drafted with the Afghan authorities, which dealt with the transfer of detainees. You'll know that to some extent this matter was covered extensively in Janice Stein and Jean Lang's book, The Unexpected War. The chapter on this is pretty extensive, much of which I will say will replicate what is said in that book. And members of the committee will recall that we decided to undertake the combat mission after we had put our PRT in place, and to support our PRT as a process to move control of the southern area of ISAF from the exclusive area of operations of the Americans. I think that's part of the picture, that part of what we were doing in southern Afghanistan at that time as a political issue for the Afghans was that we were transferring authority from exclusively an American command to an ISAF command, which would have taken place after we had had our original combat mission, you'll recall, but took place in June of the following year. It was a very different type of mission. The role of the Canadian forces was to provide primarily security for the political process to take place, which was coordinated with CEDA and DFATE, essential partners in the 3D process. I'd like to emphasize that in our view, the rule of law was an important component of our campaign in Afghanistan, both from a legitimacy point of view and our credibility with the Afghan population. The question of detainees was a difficult one that we had to resolve. There was no capacity in the Canadian forces to manage large numbers of detainees. That was clear. We didn't have the number of troops or the type of infrastructure that would have allowed us to do that. Early discussions with NATO had indicated that NATO had no intention of providing a detainee holding capacity. The Americans had capacity in Bagram, but in our view, not only was this getting to the point where they were resistant about taking more detainees, it also was true at that point that because of both Guantanamo and our experience with Abu Ghraib, we were not of the view that the Americans would be appropriate authorities to receive prisoners from Canada, and that matter was raised in the debate in the House, which I'll come to later. So that takes us to the point that we are in Afghanistan. We were in Afghanistan, so the Afghans were the logical and appropriate partners with built-in protections for the prisoners, of course. The Dutch, the British, the Danes were working on this solution as well. And we had a sense of promise that things were improving in Afghanistan. So from a chronology point of view, in May of 2005, Foreign Minister Abdullah and I met. We agreed an agreement was necessary and would have the support of both the Afghan and Canadian governments. We discussed the idea of a transfer with Afghan authorities again when I was in Kabul in October. Foreign Minister Abdullah was keen. President Karzai gave his okay. Defense Minister Wardak, however, made the point that the Afghan forces had no capacity to deal with detainees, but that the President had agreed that a special force would be trained to handle them. We therefore proceeded to work on an agreement, which was drafted with senior members of the Judge Advocate General's Division in the Department of National Defense, in fact, one of whom was a doctor in international law. They were in contact with and had complete support of their colleagues in Foreign Affairs and PCO. There was an understanding that the Dutch and British were working on similar agreements and would be transferring prisoners to the Afghan Authority as well. The agreement contained, as you know, amongst other provisions, the Geneva Convention protections, whatever the detainee's classification. The Red Cross was to be notified, and provision that the Afghan Human Rights Commission was to be engaged. This, I want to emphasize, colleagues, we believed was an extremely important provision. It was a part of what we believed was building civil society in Afghanistan at that time, giving capacity to the Human Rights Commission of Afghanistan. I have to say that I have subsequently had the opportunity of meeting Dr. Simar, who you will recall was the president of the Commission. She was in Toronto as recently as a couple of weeks ago, attending a meeting. I met with her, and she assured me that the Afghan Commission at that time took their role extremely seriously. They investigated prisons, and while they had problems, they certainly were doing their best to ensure that prisoners were looked after, and they did take their role extremely seriously. And we added a provision that there would be no death penalty, which, as you recall, was added as a result of conversations which we had in the House. When we had finished drafting the agreement, our officials assured me, and I pushed them hard on this, that our agreement contained the best language possible for the protection of prisoners. I think it's appropriate at this point to emphasize that the agreement was drafted in anticipation. We had very limited experience with prisoners in the system at that time, and so while we were aware that the Afghan prison system was not perfect, in fact was wanting in many respects, we had no reason to believe that they would not be capable of treating prisoners in accordance with the international humanitarian obligations set out in the agreement. In November of 2005, we met here with NGO representatives, and I can say that there was general agreement that the appropriate approach to this issue was to transfer prisoners to the Afghans rather than the Americans at that time. Concerns were expressed about Afghan prison conditions, something that we were going to address through CETA, but there was every support for the policy of transferring prisoners to Afghanistan at that time. And some members in the room will recall that the question of prisoners was raised in the debate in the House of Commons in November of 2005. I raised the agreement, and various opposition members raised similar concerns about any transfer to U.S. authorities. But as I understood it, supported transfer to Afghan authorities provided proper provisions respecting the Geneva Conventions were present. It is true, this agreement lacked a right to follow prisoners, something contained in other agreements. This agreement was criticized for that, and with hindsight, it could have contained such a provision, which the present government, in its wisdom, added. I must emphasize, however, that at the time we believed we had an agreement that contained the highest level of protection for any possible prisoners. In the end, the agreement was not perfect. No agreement is. Every agreement depends as much on the way in which it's applied as to how it is written. For myself, members, I want to assure you, Mr. Chairman, that I was motivated in pushing on this issue because I believe that this was a political struggle in Afghanistan and required demonstrating that we as Canadians operated under the rule of law. Mistreatment of prisoners would weaken the legitimacy of our role in Afghanistan itself and the support that Canadians would give the mission at home, a position that I believe I fully canvassed with members of the House during the debate which I spoke, and when I welcomed the observations of the honourable members of the opposition. You will also recall that the subsequent debate about extending the mission, I've read Hansard and seen that this question of prisoners in May of 2006, when we discussed the extending of the mission, was only mentioned on 2 occasions in that lengthy 6-hour debate. Colleagues, or rather not colleagues, but Mr. Chairman, I remain confident that the Canadian Forces are imbued with a sense of operating under the rule of law, something that General Hillier and General Natinchuk have emphasized on many occasions, which I personally experienced, whether dealing with our soldiers or members of the Judge Advocates Division. I'd also like to pay tribute to the members of the Judge Advocates Division, legal officers, and many other officials who, as you may know, serve in the field at the risk of their lives and provide instant advice to ensure that our troops are conducting themselves in accordance with their obligations under the Rome Statute and relevant provisions of international humanitarian and Canadian law. As I said at the opening, I wish you, sir, and members of the committee, honourable members, well in dealing with this issue in a way that ensures the reputation of Canada as a promoter of international humanitarian law is preserved and the integrity of our armed forces is protected. Thank you very much.
Thank you very much, Mr. Graham. We'll move to the first round of questioning. 7 minutes. Mr. Ray.
Mr. Chairman, first of all, I have to declare that I succeeded Mr. Graham as the member for Toronto Centre, so I'm very conscious of his contributions not only to the House but also to our shared constituency. I wonder if Mr. Graham, in your first point being that there was a process of elimination that went on to determine how what the policy on transfers would be, and you stated at the outset that there was no capacity to manage the detainees from a Canadian perspective. Did you do any, were there any studies or any reports or any discussion that you were aware of that said this is what it would take for us to handle our own detainees? This is how many we think we're going to have. This is what we think we'll need to do. Were there any sort of analyses done of what exactly would be involved?
Well, I understand that I certainly wasn't party to those. I was advised that discussions had been held, but you'll recall that we had the PRT, which was fully occupied in dealing with its issues. We had the number of troops that were on combat mission, and certainly from the Defense Department's point of view, at that point, the department was very stretched in the number of soldiers we were sending to Afghanistan and what they were doing. There was definitely a strong opinion at the leadership level that to have diverted troops to the process of managing prisoners would have made the combat mission itself, would have impinged on their ability to conduct the combat mission. So this was not a matter that was just our problem. The British were discussing the same thing, the Dutch, as I said, the Danish, everybody came to the same conclusion. There was an unsuccessful attempt to suggest that perhaps NATO would have been a logical possibility of providing one of the countries in NATO to provide a detainees supervision brigade or something of that nature, but NATO wasn't willing to pick up that challenge, so that didn't go anywhere.
When you say that there were NGOs present at a meeting you had in November of 2005, we've heard from a number of NGOs over the last several months and indeed over the last couple of years with respect to the treatment of prisoners. Can you tell us which NGOs, can you remember, or do you have a record of that meeting as to who was there?
Yes, we do actually have a record. It was with Amnesty International, and I have spoken both to the Department of Foreign Affairs note taker and to someone from my own department who was there, whose records are clear that we were in total agreement that there was no way that under the circumstances at that time that it would be appropriate to turn detainees over to the United States, and that since we were in Afghanistan, Afghanistan was the solution, but of course with the proviso that Geneva Convention protections had to be written into the agreement, and it had to have some fence around the way in which they'd be treated.
But the Geneva Convention requires that if there is a substantial risk of torture or mistreatment, that prisoners are not to be transferred. And the central problem, it seems to me, is that the evidence would suggest that there was a substantial risk, and indeed you could argue that there is a substantial risk today, given the widespread evidence and widespread reporting of the mistreatment of prisoners either by NDS or by other Afghan prison authorities?
Well, I think that's very much, if I may suggest, the benefit of hindsight. It was not at that time evident to us that there was such a substantial risk. In the first place, we at that point had, to my knowledge, not taken any prisoners, so we didn't have experience with prisoners. It is quite correct to say that the literature shows that there were problems in the Afghan prisons, but as you know from the matter from Toronto Centre, there are problems with the prisons in Toronto. There were 3 young people killed in the Dawn jail within the last year. So every prison system has its problems, including our own. So you have to balance that to recognize that we were dealing with a country where we were trying to help them build a prison system, that this was a part of what we were building, that we were providing aid for that at the same time, and that this was a part of a process of moving along. I think it's fair to say that the military leadership at the time did not foresee the number of prisoners that were going to be taken. I think in fact, General Hillier gave that evidence before the committee, that in fact, this was a surprise, the number of prisoners the one took. So we were operating, if you like, in a somewhat theoretical rather than a completely knowledge-based world at that time.
The other criticism that's leveled at the agreement in 2005 agreement is that other countries managed to negotiate an ability to actually physically inspect facilities themselves, and that we left it to the Red Cross. How do you respond to that?
Well, that is certainly is a criticism, and that is something that was subsequently rectified in the subsequent agreement that was drafted. It is a question that what we call the monitoring issue. How are we to monitor? In this agreement, we believe that the monitoring by the Red Cross was going to be sufficient. Other countries chose to put a monitoring provision in, but I know that at least in the case of the United Kingdom, they're having similar discussions in their parliament today about how successful their agreement was in working as well. So, which takes me back to my point that agreements are all very well, but it's the way in which they're applied that makes them successful or not in the end.
There's also a question of capacity as well. I mean, one of the things that's very clear, I was in Afghanistan in 2006. The embassy was tiny. There were 2 officers and an ambassador. There wasn't a capacity to inspect anything. You wouldn't have had the people to do it. Well, isn't that part of the problem?
Well, that was certainly part of the problem, because it was clear that while it was the role of the military to turn the prisoners over to the system, it was going to have to be the civilian arm that was going to have to do the monitoring. From reading what's been taking place before this committee, obviously evidence has said that was one of the problems that subsequently arose. So, but I can't honestly say that we foresaw all of that at the time. We didn't, or we might have acted differently. But we did believe strongly that the provisions in here for the both not only for the Red Cross but the Human Rights Commission being involved, we felt was adding a dimension which would make an important Afghan buy-in, if you like, into the management of the system that would be very important for them and very important for us in terms of what we were trying to build in Afghanistan.
Thank you, Mr. Graham. Monsieur Bachand, vous avez 7 minutes.
Mr. Bachand, you have 7 minutes. Thank you very much, Mr. Chair, and welcome, Mr. Graham. First, Mr. Graham, I would like you to explain to the committee why the 2005 agreement was signed by Minister Wardak, the Afghan Minister of Defense, and General Hillier, because that has always seemed rather odd that an elected official should sign a document, and that the Chief of Defence Staff of Canada also should sign the same document. Did you ask General Hillier to sign that 2005 agreement? Well, Mr. Bachand, at the time, You and I and all the other members of the committee were in the process of obtaining a mandate from the Canadian public. We were in the midst of elections, and this mandate changed the behavior of the government. But what I can tell you is that if I understand correctly the circumstances of the signing of this agreement, General Hillier was in Afghanistan, and you will understand that our troops deployed over a period of 3 months. So at the outset, the negotiation of this agreement was very important for us. It was important that it be concluded by the end of the year. The agreement in question had the approval of our department and of the Foreign Affairs Department. And if General Hillier had not signed off on that agreement, then Mr. Spruill would have done so. That is clear. The ambassador would have signed it, the Canadian ambassador. But according to what I was told, General Wardak, since he had a personal relationship with General Hillier, which dated back to the ISAF period, had asked General Hillier to sign the agreement on behalf of Canada because for him it was a question of trust and personal relationship. That is what I know regarding the decision. General Hillier agreed, and instead of having it signed by the ambassador, and then we know what happened after that. But it's not General Hillier who negotiated the content of that agreement, is that correct? I imagine that it was negotiated by DFATE and looked at by the defense minister, and then you would have said, well, Hillier, given that you're there, we said we'll send you the agreement and you can sign it. Well, I would say that it was negotiated by our Department of Defense with the agreement and the approval of DFAT because it was General Wardak in their system who was responsible. Now, General Wardak was responsible for the Afghan army, and for us, the Afghan army was our partner. He was also the minister responsible for prisons, as well as being the defense minister at the time. So he was, I would say, the standard interlocutor, and it was me who spoke with the Minister of Foreign Affairs, Mr. Abdullah, and with President Karzai, with the agreement of DFATE. But it was our defense, our ministry, our department, who had the lead in this matter. Mr. Graham, in that agreement, do you acknowledge that there was an important aspect that was missing with regard to prison visits, with regard to follow-up? Because it would appear that that was not included in the agreement as such. So why was such an important aspect left out? It's all very well to say, okay, we're going to proceed this way for the transfers, but if there's no follow-up, if there's no monitoring, well then there are still allegations today. I'm sure you heard about the statements of General Laroche yesterday, who said, well, the DFATE officials did not want to perform follow-up. He said that they were not protected, and it is clear that there were periods where there was no inspections. There were no inspections of the prisons, and therefore that we couldn't be sure that the Geneva Convention was being respected. Yes. And my problem is that my mandate as minister ended on January 15th. All the discussions, all the finger-pointing, if you will, all that happened and occurred during the period after I left office. So I don't have any knowledge of what the actual problems and issues were. I didn't experience that. What I experienced was the negotiation of the agreement itself, and I can tell you that it was in very good faith that we negotiated that agreement with the protections under the Geneva Convention. You'll remember yourself, Mr. Bachan, I have a good memory. I heard you say in the House that you said, sign an agreement with the Afghans, and you will have the support of the members of the House as long as they are protected under the Geneva Convention. And I said, okay, we'll do that. Now perhaps we should have included follow-ups in that agreement. But yes, I already stated the agreement was not perfect in that regard, but it was the best we could do at the time. Fine. All right. You wrote a letter to Mr. Martin on May 27th, 2005, in which you said that you wanted to ensure that the prisoners were well treated under the Geneva Convention. And it would appear that you came up with a mechanism at the time.
Information on detainees to the International Committee of the Red Cross, which has the mandate and resources to track prisoners of war and detainees captured during armed conflicts. However, it does not clarify whether the ICRC would report back to Canada on the conditions of detainees. Alors, est-ce que vous reconnaissez que vous avez écrit ça?
So do you acknowledge that you wrote that? Yes, absolutely. Well then, you asked the Red Cross to follow the detainees, but it was not stated how the Red Cross was supposed to report to you on that. And we have learned in the meantime that the Red Cross is very secretive about how Afghan prisoners are detained in prisons because they don't want to not be able to go and visit them. Well, we know that the policy of the Red Cross is to report to the nation where the prisoners are detained. We underwent the same thing with Guantanamo and the prison there. The Red Cross said, we will report to the American authorities. We will not report to any other countries. And you will recall that that was a question that was debated at length in the House before I left. We needed to decide whether it was a responsibility of the Red Cross. But it is clear that the Red Cross reports on what occurs in the prisons, but does not report to the authority, to any other authorities. Now, I have a very important question for you. First, you were Foreign Affairs Minister, and then you were...
Thank you. We'll come to Mr. Hahn.
Thank you, Mr. Graham, for being here, and thank you for your leadership in the House during debates to extend the mission back in 06 and 08. As an international law expert in your own right, and I think you've said it, I just want to hear you repeat it, you were certain that the provisions of the 05 agreement met Canada's international obligations under international law. Is that fair to say?
Yes, although, to be fair, sir, I'd been out of teaching international law long enough to know I'd better rely on people that really knew what they were talking about. And I like a minister should, I relied on the advice of the officials in the department who were backed up by the foreign affairs officials. I mean, that was the advice I got, and certainly everything from my own experience told me that was good advice.
Okay. Now, people have characterized the 05 agreement as flawed, and I think in hindsight, as you said, we could probably point at that. But at the time, it's fair to say that you entered into that agreement in good faith, based on the information you had at the time?
Absolutely. It was the best. We felt it was the best agreement we could get in the circumstances.
Do you think it's fair to say that when government changed and the current government assumed the mission in 2006, that we assumed that agreement also in good faith? I know you can't speak for the government, but would that be logical that we would have assumed that agreement in good faith?
Yeah. Oh, absolutely. I mean, I'm assuming you do everything in good faith.
Well, of course. Now, it's for
others to determine whether that assumption is correct or not.
But that would be perfectly logical.
Yeah, of course.
Now, just one slight correction: we did take prisoners before the end of 2005, because there was a situation with Minister Eggleton and some prisoners that were taken.
No, I'm sorry, I didn't mean to suggest we'd never taken prisoners.
Yeah.
And in fact, I think the facts would show that all the prisoners taken before were transferred to the American authorities. Correct. As being the authorities that were, at that time, was Operation Enduring Freedom. They were in command of the field.
But, subsequent to that, and because of some of the political considerations of Abu Ghraib and Guantanamo and so on, the government of the day's judgment that it was better to transfer them to the Afghan authorities at that point than to American authorities.
Yeah, and there certainly was a factor of, as I suggested, the problems that were arising under Abu Ghraib and Guantanamo. Those, however, In the early stages, we didn't know about that. Those were things that were becoming very, very courant at the time. But I would suggest that the other really important factor was we were in Afghanistan. It's Afghan sovereign territory. We had to demonstrate that we are operating within a role to contribute to the pacification and the building of Afghanistan for them, not for ourselves. And I think ourselves, the British, the Dutch, and others all came to the same conclusion. The only proper conclusion, given the circumstances of the nature of our mission, it wasn't an invasion, it was a mission to support the building of a government there with a newly elected government, that the only thing consistent with what we were doing there was to concern them, the sovereigns in their territory, and allow them to take the prisoners, to be responsible for them.
And we talked about, you know, the strength of agreements, and you had an agreement in 05, and there was a supplementary agreement arrangement in 07, that, you know, agreements are fine, but it's the people who are administering. The agreement can be perfect. If you have imperfect people applying the agreement, you might get an imperfect result. Is it fair to say that in a country like Afghanistan, working with some pretty imperfect institutions and people in the context of what we would expect, that we're going to see some stumbling on their part?
Yeah, I think that's absolutely fair to say. Certainly, it wasn't just in respect of this issue. We know about drugs, we know about corruption, we know about all those issues in Afghanistan. I mean, what we were struggling was to try to correct all of that, for sure.
And part of our mission there, of course, is to, and continues to be, to correct where they fail, to meet our expectations, to continue to work with them to raise their capacity and raise their, you know, their adherence to the rule of law.
Absolutely. Yes, sir.
Knowing full well that they will from time to time fail, does that make their failure our failure? If they fail...
No, well, it depends what we do, obviously, in terms of what... so it's very difficult to make an abstract statement of that effect, but I don't think we can be asked to be responsible for all of the problems of Afghanistan once we've gone there. In fact, we're there to try and support their improvements. Absolutely. I agree.
And when your government found problems, you tried to fix them.
Yes, sir.
And I would suggest that has been the continuing pattern of governments, regardless of which stripe they are.
Yeah.
Would you...
Yes, sir.
Tend to agree with that?
Yes, sir.
I'm going to make a statement here. One of the things that I found concerning is that we in Canada tend to put a Canadian context onto Afghanistan and the Canadian perspective, i.e. that, you know, we expect people to operate to a level that we operate in Canada, but you said yourself, of course, that we have problems. Every prison system has its problems, including ours. So it's a matter of degree. Would it be, you know, I'm going to make a statement, see if you agree or not, that in my view, nobody is guilty of anything, whether it's the previous Liberal government or this government, and certainly not the Canadian Forces, that nobody is guilty of anything other than doing the very best they could under incredibly difficult circumstances in an incredibly difficult situation, working with incredibly difficult people.
Well, I totally agree that everybody, as Canadians, are trying to do their best in Afghanistan in a very difficult situation. Absolutely. And doing their best for Afghanistan, for the international community, and what we're trying to do as Canadians. Whether there may be one or two circumstances where, in fact, an offense was committed of some kind, what I would suggest is that I think we have a system in place in forms of a military justice system and a civilian justice system that will ensure that if in fact the facts ever point to such a circumstance, that it will be dealt with appropriately by the judicial authorities. Up till now, I haven't heard of anybody being prosecuted for anything, and so in my view, the facts, I think that is exactly where we are.
Okay. You know, we talk a lot about hindsight, and obviously it's always 2020. Do you think anybody could have predicted, your government, our government, you know, the ferocity of the war or the conflict or the combat that was going to break out in Kandahar in 2006?
Thank you, Mr.
the
Hahn.
level of casualties and so on?
Well, I think it's fair to say we did not. I mean, look at the nature of the equipment we took when we went. We took it LAV-3s, and we ended up getting tanks. I think there was a whole host of assumptions made when we first went to Kandahar, that in terms of equipment and other things, we had to get helicopters that we originally didn't have. We perceived of a campaign that would be much more active in going into villages and dealing with people, where we found that subsequently the security element, which was determined largely by the use of IEDs and other forms of explosive devices, that made it impossible for us to conduct the type of campaign that was envisaged at the beginning. I think that's a perfectly accurate description of what happened. It evolved, and the enemy evolved largely from lessons they picked up, I think, in Iraq and other places.
Yeah,
Thank you very much, Mr. Graham and Mr. Hahn. We'll now move to Mr. Dewar, please. 7 minutes.
Thank you, Chair, and thank you, Mr. Graham, for your being here today and providing us with your testimony. I just want to clarify a couple of things and just very straightforward questions. I want to get from you, did you okay the agreement in the end?
Well, I didn't. Yes, we had agreed on the terms that were in the agreement that was subsequently signed by Mr. Hillier were terms that have been...
I want to be very precise here. The agreement that was signed off at the end of the day, you okayed that final copy of that agreement.
We would have okayed the final before General...
But did you okay the agreement? It's important because I'm not sure from your testimony if you okayed the agreement or if it was someone else. And I would take it if it wasn't you, that it would be General Hillier.
Well, I don't believe General Hillier just went off and signed something.
No, I'm not saying that. I'm saying, did you, at the end of the day, okay the final copy, the final agreement?
I don't recall at any point someone saying, here, Minister, initial this. But that is the agreement that we had discussed with our officials, and our officials had discussed with Foreign Affairs, and everybody had agreed that that was the agreement we were going to put to the Afghan authorities, and it had been discussed with the Afghan authorities. So in that sense, yes, I certainly agreed with that agreement. I would have, based on the letter that I had sent to the Prime Minister and getting the authority I did, if I'd had authority, I would have signed it myself.
But I'm hearing from you that you're not entirely sure if you okayed the final agreement, but the spirit of it and the general thrust of it, you okayed.
Absolutely.
Did you talk to General Hillier before the agreement was signed off?
No, I was talking to my constituents.
No, I appreciate that, but I'm just, you also had 2 roles and you were still the minister.
No, I appreciate that. I'm not trying to avoid my responsibility, but General Hillier was in Afghanistan. He had the opportunity to sign it, and he signed it.
So there, at no point you had a conversation with him to say, here's the agreement, you're okay with it, and he gave you feedback. So there was no feedback from him.
But that agreement was approved before he left.
By you?
By me, by the Department, by Foreign Affairs, by the Government of Canada. That agreement was approved by the Government of Canada.
By you?
Fine, by me.
Okay. I'm having problems just getting the...
Well, I mean, you're trying to draw sort of a picture of, did someone put the agreement before me and say, yes, here, initial it. I can't honestly
Well, normally, would that be the process? That would be the process?
No, I mean, that's not the way...
For agreement like this?
Agreement, not necessarily, partly because this is a form of a memorandum of understanding. This is not a formal treaty.
But it's an agreement between 2 countries.
It is, but it's a memorandum of understanding. It is not a treaty, and wouldn't go through the normal treaty process of seals and approvals.
No, I fully understand that.
Cabinet and all that stuff. It was a totally different type of agreement. The British agreement is the same. It's called an MOU. If you look at the other agreements, they're exactly the same.
So the involvement of General Hillier then was simply to, as you stated, to meet with General Wardak and to sign it off, and that was it. Did he at any point give you input as general? Because my understanding, from what you're telling me here, I'm just trying to piece this together, and I did take the time to read The Unexpected War around this, and there was some, and your testimony today, it's clear to me that it was actually something that DND seemed to be the lead on. Is that correct in terms of the transfer?
It may be fair to say DND was the lead, but it was very clear that it had the full support of the other key department in the Government of Canada in this affair, which is the Department of Foreign Affairs. And I am assured that if General Hillier had not signed the agreement, David Spruill, as our ambassador, would have signed it in his place, in which case we wouldn't be having this conversation about General Hillier. We'd be wondering whether David Spruill was authorized to sign it or not.
Well, it's not a matter of authorization. It's a matter of why the person who signed it. And I guess there's some confusion here because the only rationale I can glean from what was written in the book and testimony from you is that General Hillier knew General Wardak well, and therefore it was a convenient way to sign off the agreement.
General Wardak, as I understand it, actually asked General Hillier to sign it. Because for his perspective, General Hillier, because of his personal relationship with him, carried more credibility than anybody else in the system.
Do you think that was appropriate?
Well, if I'd been there, I would have signed it. It wouldn't have been appropriate for General Hillier to sign it if I'd been there.
What I'm
Of course
saying
not,
is it
but I
wouldn't
don't
have
think
been
under
more...
the circumstances it was inappropriate or it was appropriate. As I said, it would either have been in the ambassador to sign it or for General Hillier.
Well, I guess I'm asking the question because I think most people would, notwithstanding it's not a formal treaty, that this agreement was something that Canada was wanting to have established with the government of Afghanistan, and the terms of which should be, I will say, our terms with agreement of the Afghan government. So I'm finding it, I'm a little uncomfortable with the fact that we would have asked General Hillier because General Wardak knew him well, and therefore they could, have a conversation and sign it off. I say that because, first of all, I thought that was the job of our diplomats. And if they're speaking on behalf of the government, it's on behalf of usually that's done by diplomats, not by generals. So I guess my question is, why was it that General Hillier was allowed to sign that agreement when normally that would be the job of a diplomat?
Well, I can't answer that question because I wasn't there and he wasn't in communication with General Hillier or
But
David
who's in
Sproul.
charge? I'm just asking, who's in charge of this file?
Well, the government of Canada is in charge of this file. General Hillier's a leading member of the government of Canada.
But he's not an elected official.
No, neither is David Sproul, the ambassador.
No, but he was be
These are
delegated
signed by officials. He's an official.
Well, I guess what I'm
The government of
asking,
Canada.
why I'm asking this, Mr. Graham, is that through the chair, is that they're delegated these authorities
Right.
as diplomats and as generals. And in my view of the world, when we're talking about delegated authorities that are as important as transfer of detainees, and realize the role of DFAID officials after, and if we get a chance to talk about that, we'll get into that, because they ended up having to do monitoring. But what I'm hearing is that the delegated authority was to the general and not to the diplomat, and you don't have any reason other than to say it was convenient for the general.
No, look, I mean, I don't disagree with you. It's unusual. But there are lots of cases in international agreements where they're signed by military people or others when they're, I mean, there's lots. You can go back into history where all sorts of, the rendition of Germany was signed by a bunch of generals and admirals. That was the ending of a war.
It was a delegated authority.
Thank you.
These are
We were in the middle of a
that
war.
was a big deal. That was a really
We'll come
big
back
deal.
to the government side. Mr. Deckard, please.
Thank you, Mr. Chair. Thank you, Mr. Graham. I appreciate you being here this afternoon. When we first met, you were a professor of international law at the University of Toronto Faculty of Law when I was a student there. So it's very interesting for me to be at the other end of the questioning spectrum today. And as a noted expert in international law, I have a question for you. In your view, does the prohibition against refoulement pursuant to Common Article 3 of the Geneva Conventions apply to the transfer of detainees by Canadian armed forces to the Afghan authorities in these circumstances, the circumstances of our current mission?
Whenever I went to all candidates meetings and somebody called me a professor, I knew it was usually because I was going to get into trouble. So I can tell the member is using unfair tactics. But somebody mentioned to me this term refoulement, which, as I understand, is a matter of a term of art which deals with refugees if they're turned back at a border by a government and the refugees are coming across and they're refouled, in other words, and put in harm's way by being returned. I haven't studied this situation with that in mind, so I wouldn't want to give you an instant opinion on it.
recall
But
whether you got any advice on that at the time?
I wouldn't have thought at first blush that this is a case of refoulement in that sense, as I understand the use of the term.
Well, that's interesting because Amnesty International and Human Rights Watch, for example, the lawyers that presented here from each of those organizations absolutely do think it does apply in this case, and that Canada is bound by that. But that's their opinion. I'm not taking their side. I'm just pointing that out. Okay, I just wanted to hear your view on that.
As long as we understand that opinions in international law tend to be many and varied,
like any legal matter, of course.
Right.
Human Rights Watch and Amnesty International and several DFAID officials, such as Eileen Alexiak, have all stated that allegation of prisoners by abuse of prisoners by the Afghan NDS were common knowledge in 2005 and in earlier years. In fact, Human Rights Watch told us that they had presented reports dating back to 2002, 2003, 2004, alerting the international community about serious allegations of abuse by Afghan authorities. Were you aware of those allegations in 2005?
No, I honestly was not, but I have to say I have great respect for Human Rights Watch. They do extraordinary work, so I wouldn't dispute what they would have said, but they were not reports that have been brought to my attention about Afghanistan, either when I was foreign minister or defense minister.
Okay, well, that's interesting. The lawyer for Human Rights Watch that appeared before this committee last week mentioned to us that she thought that transferring prisoners to the U.S. at Bagram probably would have been a better choice. How do you respond to that?
I honestly don't know how to respond to it, because you probably could make a case for that in general, the United States authorities probably had a better capacity to deal with prisoners than anybody else. They had more personnel or experience. But the problem was we were dealing with a situation with the American authorities that I do not believe we would have been able to get an agreement with them, either about the Geneva Conventions or the way in which the prisoners would have been. And if somebody was transferred to Bagram and then sent to Guantanamo or one of these other places, what recourse would Canada have had? So I think that was the position that we were in. I mean, I'm not suggesting that the Americans are evil or anything, but they had serious problems at that time, and that was, as I said, if I go back, if you were present or if you'd been present in the debates in the House, it was very clear that all parties in the House at the time were clearly of the view that it would have much better to deal with the Afghan authorities than the Americans.
In your view, it would be more likely that prisoners would be abused by the American authorities in 2005 than by the Afghan authorities?
No, I didn't say that.
Okay.
No, I wouldn't say that. No, that would be a very unfair characterization. No, I certainly would not say that.
Thank you. That's our 5 minute. The second round is a 5 minute
But I wouldn't
round.
say that.
Mr. Desange.
Thank you, Mr. Graham. You said that in drafting this agreement or negotiating this agreement, you had the advice from JAG, the officials of JAG. Do you recall the names of the JAG officials who advised you or drafted the agreement?
Well, the principal advice I would have got would have been from the then Judge Advocate General himself, General Pitzel, who was the Judge Advocate General, and he had two colonels with him, one of whom I was told had a doctorate in international law, was experienced international lawyer. But obviously, General Pitzel was as he pointed out, he said he had the role as the legal advisor to the Minister of National Defense, and I very much took his advice. He was a very scrupulous, careful lawyer.
Do you recall the name of the colonel?
No, I couldn't recall it.
There have been arguments, Professor Graham, if I might call you affectionately, There have been arguments advanced by various legal authorities and others that the evidence that's known in the public domain or otherwise establishes a substantial risk of torture for any detainees transferred to Afghanistan. And some of that evidence, according to Madam Alexiak, who testified before this committee, relates to the period that you were the minister for. The arguments have been made that if you are capacity building as you continue to transfer, even in the face of that substantial risk of torture, that somehow you can be immune to any allegations of offenses under the Geneva Conventions. If you are capacity building and you're trying to alleviate the problems, yet you continue to transfer. Is that your view?
No, I wouldn't have accepted that view. You're suggesting, in other words, that because one is capacity building, one could go and make a transfer in the face of total knowledge that, in fact, this was going to result in torture? And because, no, I wouldn't accept that. I mean, obviously, that's not a justification for that. The responsibilities under the Rome Statute, and in fact, the War Crimes and Crimes Against Humanity Act, which is part of the legislation of Canada, as part of our criminal code, don't have a proviso in it saying, no, but if you're capacity building, you can go ahead and do it. I don't think that's, no, I wouldn't accept that.
And nor does simply transferring detainees to Afghan authorities absolve us of our responsibility. Is that your understanding?
Yes, but that responsibility is not absolute.
How so?
Well, I mean, again, you'd have to get some international lawyers to help you with that. But the transfer having taken place in good faith with a full understanding that the responsibility of the Afghan authorities would be properly exercised. If something is subsequently done, the Canadian authorities can't be held responsible if a year later the Afghan authorities go and do something crazy. I mean, no criminal code system operates, to my knowledge, in that respect. I mean, but you'd have to get a lawyer to tell you that. I mean, what we do is we're responsible if in the face of, if I understand, of knowledge of what you do. But you can't be responsible for what you don't know about. It's not an absolute responsibility. There's no such thing.
Let me make the argument that is made sometimes by legal scholars, that if you know, or you ought to have known, because there's a positive duty to find out, if you know or you ought to have known, or you knew or you ought to have known that there was a substantial risk of torture and you continue to transfer, if something happens to a prisoner or prisoners, we are responsible as a country despite the fact of transfer. That's my understanding of the law. Wow. And just because it happened after the fact does not absolve us. I'm making that argument because the argument made by some colleagues from the government has been that you ought to have known because there were reports in the public domain in 2005. Madam Alexiak argued that there was sufficient evidence in the human rights reports that she wrote. I'm saying this because I want to give you a chance to respond. Done?
We'll move back to Mr. Deckard, please. I got to get used to this 5-minute, not the 7-minute round. If you want to answer very quickly, okay, Mr. Graham.
Well, Mr. Chairman, I mean, the honourable member, and I don't want to get into a legal argument with him, has totally jumbled up what international lawyers make the difference between the law of war and the law in war. There's personal responsibility under the Geneva Conventions for individuals who they do certain things under the law of war. The law of war, which governs the responsibility of countries, is a different matter. Wars of aggression, human rights. So I honestly, I don't accept what the member said in terms of a country's responsibility, because what he's talking about under the under the War Crimes Act, as I understand it, is a war crime of individuals, and therefore would have to be proved in a court of law that they knew or ought to have known and failed to exercise their responsibility. But there are greater international lawyers than myself around, and they can maybe help the House with that. But,
thank you,
but
Mr. Graham.
It is a problem.
Mr. Deckard.
Because we're running short of time.
Yeah.
Just to clarify, I was just telling you what Amnesty International and Human Rights Watch lawyers had said, not what I believe.
Okay.
Did you read the Dutch or UK transfer agreements in 2005 while the Canadian agreement was being negotiated?
No, we did not have.
Were you aware of them?
We were only aware that there were other agreements being negotiated at the time, and was not aware of them. I was given, my recollection is actually that when we were discussing this matter in the House of Commons in November in the take note debate, my recollection is Mr. Blakey raised the matter of detainees, and he gave me a copy of the Danish agreement, I believe.
Okay.
And I took that to
UK
the authorities and said, are we getting as much as the Danes do?
But can I ask you a question? You mentioned that you have great respect for Human Rights Watch.
Right.
They have told us that in their view, diplomatic assurances that there will be no abuse are not sufficient, in fact, are never sufficient, and there should be monitoring. And yet, the Canadian agreement didn't provide, that you okayed in 2005, did not provide for monitoring. How do you respond to Human Rights Watch?
Well, I mean, I respond by saying that we believed at the time the two provisions for monitoring that were put in the agreement, namely the Red Cross on the one hand and the International, or rather the Human Rights Commission of Afghanistan, were monitoring procedures that would satisfy our responsibilities in international law, and that was the best we were going to get from the government of Afghanistan at the day, and we had to get this agreement signed.
Enough. Can I ask you a question? Do you believe that any Canadian prisoners transferred to the Afghan authorities have ever been abused since that agreement was signed in 2005?
I really couldn't speak to that.
Have you ever heard?
I would really say, sir, that if you're talking, I mean, we're talking here.
I just want to know what your belief is.
No, we're talking about criminal responsibility for individuals for acts.
Fair enough.
And as a cautious lawyer, I would suggest that one should allow tribunals which are established for that purpose to establish those facts.
Okay, fair enough. I'll defer to Mr. Abbott.
3 minutes.
Mr. Graham, we've already had two people say speak of the high regard they have for you, and certainly you and I had some good times in the House as political opponents, and I have the highest regard for you. And the reason why I make that reference is the fact that I want to ask a tough question, and it is not done flippantly. Opposition members and other people who have appeared, as well as commentators, have said that the government violated its international obligations under the Geneva Conventions and humanitarian law. Essentially, they are accusing government ministers, past, yourself, and present, of being war criminals. I don't suggest that that is...
That is a ridiculous comment, Mr. Chairman. No such accusation has come from an opposition member. I've never heard of any such a
I believe it's my 5 minutes, and I'm not going to get into an argument with Mr. Ray. The fact is that the term war criminals has been bandied around in these hearings. I would like to have your comment, please.
Nobody's ever used the term. You've used it.
Well, it is a tough question because you really have to know the circumstances, and I certainly, I have not heard of any accusations of war criminal behavior of anybody and calling it a bad faith members of the House. So I haven't. Although I will tell you that, frankly, the internet being what it is and people being what they are, people have stopped me on the street and said, you know, what were you doing? Are you a war criminal? Because that's the way people talk. That's the type of language we're living in today. I mean, I was accused of it. We were accused of it in Vancouver by a group of young students who, about being in Afghanistan, we were war criminals. I mean, people throw these terms around. I said, are you saying, you know, we should be before the Rome Tribunal, or can you give me a date in a court of law? But people don't give you a date in a court of law. They just use the allegation.
But help us understand, as an experienced member of the government, as a former foreign affairs minister as well as a defense minister, help us understand the relationship between the Army and the people who are carrying out the orders of the government. Is there any space between them? In other words, we had a general here who very aggressively said, if there's a war criminal here, I'm the guy because the buck stops here.
Well, very quickly, I don't know about that, but I can tell you one thing I was impressed when I was Minister of National Defense was the quality of legal services within the ministry. There are hundreds and hundreds of lawyers there who actually go, and one of the former field commanders in Afghanistan told me they don't go. If you're going to attack a village, somebody says, is that a proportionate response in accordance with the Genevan responsibility and the international humanitarian obligations of Canada? They're advised by lawyers in the field on operations, and those young lawyers risk their lives along with the other soldiers to try and give the best advice they can.
Thank you, Mr.
So this is
Graham.
very difficult, but that's what they're trying to do.
Thank you, Mr. Graham. Monsieur Bachand.
Thank you very much, Mr. Chair. Mr. Graham, is it true that the Liberal government of 2005 had concerns similar to the controversy surrounding Abu Ghraib and Guantanamo? Because when you said that you had apprehensions, you mean that you did not want the Afghan prisons to become an Abu Ghraib or a Guantanamo. Is that accurate to say that? What I can say is that during the period during which we negotiated the agreement, we believed that when we were in Afghanistan, and the fact that there were problems before that with the transfer of detainees to the American authorities, as you raised in the House, that in our opinion, the best solution to the problem was to deal directly with the Afghans. That's how we proceeded. And is it true that you had three options? Take and keep, that you discarded. You could have turned the detainees over to the U.S. That was the second option. And the third option was to work with the Afghans and the local system. And that's the option that you chose. Is that what you're saying? Yes. But you did consider at one time take and keep. Now, why was that option discarded? Well, for reasons of capacity. We simply didn't have enough troops to do that and to fight the war at the same time. And with regard to the transfer to the U.S. authorities, weren't there questions around the fact that you were not sure that the Americans would treat the detainees in a humane fashion? Well, like the member over here said, with regard to the Americans, in most cases, their record is impeccable. The problem is that they were determined to transfer prisoners when they transferred it to Guantanamo. We didn't think that that was the kind of solution that was proper with regard to the Canadian government. And in the opinion of most of the members of the House, that was also the same thing. Now, I'm sure you know Ms. Alexu. No, I don't know her. Well, she is a woman with a great deal of experience. She was in Afghanistan with DFATE from 2002 to 2006, I believe, and she said that in 2005 she raised the possibility that the transfer of the detainees to the Afghan authorities raised a substantial risk of torture, and apparently the Martin government ignored these her points. Do you remember receiving her report? I saw a report in the newspaper of what she said on TV, but I didn't see the report. No, I certainly didn't see it. But Mr. Bachand? We're talking about the Department of Foreign Affairs. If this lady submitted a report, well, then she submitted it to DFATE. And you were with Defense. Absolutely, I was with DND. And there was no discussion between DND and DFATE? Well, what I can tell you is that DFATE authorities and DND authorities agreed on the terms of this agreement, and they had the support of the Government of Canada with regard to the signing of it. So that means that the higher authorities had decided that, taking all this into account, that they were going to go ahead and sign the agreement. That's all that I can tell you. I can't know what this person was thinking. Well, now I'm going to talk to you about Eugene Langley. You know him well.
Of potential abuse in Afghan prisons and the hands of the Afghan security forces, which is why we tried to negotiate an agreement. Suite à ce que M. Lang dit, puis je vous demande...
Further to what Mr. Lang said, and I'm putting the question to you, while you were minister, did it ever happen that you said to yourself, well, there's torture in Afghanistan, and you said to yourself, yes, there are risks of torture in Afghanistan. Did you ever come to that conclusion while you were minister? Well, we knew that there were risks, yes. But that is exactly why we had included protections under the Geneva Convention. If there hadn't been risks, then we wouldn't have included that in the agreement. Yes, but Mr. Graham, according to the Geneva Convention, you cannot transfer detainees if there is a risk of torture. And both the Liberal and Conservative governments always come back to us saying, yes, but when we saw the situation, we changed things. But as soon as there is a risk of torture, you cannot transfer detainees. So why did you continue to transfer them if you deemed yourself that there was a risk of torture? But there was no transfer when I was minister. There was no transfer of prisoners? No. The agreement was signed on December 15th, and I was defeated on January 16th, a month later. Yes, but before the agreement was signed, you were in minister. You were minister. Yes, but you were minister before the agreement was signed in 2005. So you're the international law expert. So you knew that you shouldn't have permitted torture if there was a risk. Yes, but there was no transfer at the time.
Back to Mr. Hahn, please.
Chair, and Mr. Graham, we've talked about the CF and we've talked about defate and so on. I mean, is it fair to say that, your government took a whole of government approach to situations like Afghanistan, and that, I mean, that's the logical approach that any government would take in that kind of a multifaceted, complicated international operation?
Yeah, we tried to do our best to do that, yes, sir.
So it's not a CF here and a defate here doing things in opposite directions. It's trying to work together for the mission.
Yes.
Could you clarify, now I think somebody mentioned Prime Minister Martin was brought into it May of 2005. Did I mishear that? Anyway, regardless, what kind of consultations went on amongst cabinet colleagues in your government with the Prime Minister, or just amongst colleagues about the situation in Afghanistan, how to deal with it and so on?
Well, we had regular discussions about Afghanistan itself, which translated into a lot of around prisoners. I can't recall any specific cabinet discussion about this issue other than, as I say, I wrote the Prime Minister get authority to work on the issue. I know that there was interdepartmental discussions, but I don't recall any cabinet discussions around that specific issue. The other discussions were largely about CEDA's role, our role, how would we fund it, what the PRT would do, whether we would commit to the combat role, etc., and our relationship to NATO, which was very preoccupying as to NATO, what we're going to do, the transfer of NATO authority from the Americans to NATO and after our role, and you'll appreciate all that. Those were the large discussions we had.
Okay, and I guess following up from that, and there's been talk about what a foreign affairs minister knew or should have known, or what a defense minister knew or should have known. In your experience in both of those positions, can you describe first the kind of activities that you would have undertaken as either Minister of Foreign Affairs or Minister of Defense with respect to a mission like Afghanistan, who you would have consulted, the kind of messages you would have received, the volume of message traffic that you would have received, that sort of thing?
Well, we got, you can appreciate, a large volume of traffic on all sorts of different issues. We had to look at the problem of what was the appropriate equipment to be sending. That was a huge thing because it was a large matter. We had to get money for it. We had to deal with all those usual problems you'll appreciate equipping. We had to deal with the relationships between the interdepartmental, particularly CEDA, Foreign Affairs, and ourselves. You'll appreciate the discussions have shown that there weren't as many foreign affairs officials in the country at the beginning as they were. You had the Manley report, things were changed. So all of those sorts of discussions would have been literally, you know, on every day practically. Once we got more active in Afghanistan, I went to Afghanistan on once as a foreign minister and once as defense minister. So on those trips, I would have met with Mr. Karzai, discussed what we were doing. So we were constantly involved in one way or another in the file.
So is it fair to say that in either ministry, the minister would be, you know, fairly inundated with information and would be, you know, relying on people filtering the information to him that they thought was most important for him to address personally?
Well, yeah, I mean, that's the way the system works. You get what you basically get what you're given. I mean, but we're also politicians and we use our judgment as well. I mean, as I said in my opening, I kind of pushed this issue of prisoners because I felt it was going to the legitimacy of the mission and it was important for us to deal with it. In the department, some people felt, you know, why were we spending as much time on this at that time? But I think everybody came around to recognizing its importance. So our job as the politicians is to put in our political input, but our job as ministers is to listen to our officials and basically base our conduct on the good advice we're getting from them.
Is it fair to say that Afghanistan today is notwithstanding continuing problems, which will probably always be there, that Afghanistan today is a better place than it was in 2002 or 2005?
Well, 2002, I wouldn't want to live under the Taliban. That's for sure. So,
post-Taliban.
Yeah. Well, it's obviously extraordinarily complicated, but I think if you're a glass half full or a glass half empty person, I tend on the optimistic side, and I think the glass is more half full, and I'd like to believe that we're making progress.
And do you think some of the activity that's ongoing in this committee and in the media and whatnot is perhaps distracting or detracting from further progress along that route? No,
I think, as I said at the beginning, I think it's really important for the committee to make sure that they get to the bottom of it and the public know transparency is there and that, you know, that we're dealing with these are serious allegations. I think the committee is doing serious work to make sure the Canadian public and everybody's assured that as Canadians we're making sure that the rule of law is being obeyed. So I don't see the committee's work as problematic in any way.
Thank you, Mr. Graham. Mr. Wilford.
Chairman, Mr. Graham, it's clear from your comments that in 2005 we did not expect the ferocity of response from the Taliban in terms of the mission that we went into, that we went in with labs and we needed tanks, and that clearly the MOU that was made between Canada and the Afghan government, one of those assurances was assurance against torture. Would that be correct?
Yes, it was. Well, the assurance was that specifically the Geneva Conventions would be respected, and so absolutely that's contained within it along with a lot of other host of things. Yeah.
My question to you is, does that satisfy, or does it satisfy Canada's legal obligation to ensure that prisoners are not transferred to a state when they face the real risk of torture? Because it seems to me that in your comments we were relying on the Afghan Human Rights Commission, the Red Cross, empowerment. I understand about capacity building for those two. That at the time we didn't, there wasn't that many prisoners taken.
Right.
And secondly, we didn't expect that we would be taking a lot, and therefore using the Afghan Human Rights Commission and Red Cross would in fact ensure our legal obligations in terms of torture.
Well, we certainly believe that the agreement was capable of ensuring our obligations, and I believe, without being completely au fait with all the facts, I understand there were circumstances subsequently when military officials decided they wouldn't transfer prisoners when they were of the view that the agreement couldn't be properly monitored and that, in fact, there was no protection for the prisoners. There was one occasion when they wouldn't transfer for a period of time because they were concerned about it. So, absolutely.
And because this was an MOU between Canada and Afghanistan, did we receive written assurances from the Afghan government that they would live up to their legal obligations in this regard?
Well, I don't know about written assurances, but I can tell you I had personal conversations with Abdullah, Dr. Abdullah, who was the foreign minister, my counterpart, about the importance of the agreement and the importance for the Canadian public to know that we were living up to the rule of law, and that in fact the success of the mission depending on the rule of law, because that's what we're there to establish. And he totally agreed with that. And President Karzai, when we raised it with him, as to why we wanted the agreement, and it was important for us to have an agreement before we began our operations in the spring, accepted those arguments. So I can't say as to whether it was a written, but I can assure you that the Afghan authorities that I spoke to were of agreement. And General Wardak himself, to be fair, when he was reticent about the agreement, it was reticent because he was concerned about his capacity to be able to make sure that it was going to be properly applied.
So since General Wardak was concerned about capacity and you had received assurances from the Foreign Minister Abdullah and from President Karzai, I would assume then that they were prepared to allow for and support the activities of the Afghan Human Rights Commission and the Red Cross to ensure that those elements of the agreement would be in fact adhered to?
Yes.
Okay. And if there are prisoners that are it was the European Court on Human Rights that said on case-by-case basis that diplomatic assurances are inadequate if the issue comes to torture. And so I just wanted to get your take on, in fact, what was expected both by us and by the Afghan authorities in terms of any transfers and how, in fact, they would be monitored either by the Human Rights Commission, which we, of course, were supporting both financially and obviously otherwise, and by the Red Cross. Was there any, during the very short time, obviously, before the election in 2006, any reports back from either Human Rights, Afghan Human Rights, or the Red Cross of any concerns that they had at the time?
No, the Afghan Human Rights Commission and the some of our own NGOs that we spoke to, and I mentioned Amnesty International earlier, were certainly concerned about the conditions in the Afghan jail. It's not the same as torture.
No, I understand.
But they were concerned about the level of conditions, and I think that was a legitimate concern. And that's why one of the things we had to do was provide some correction officers and CETA money to help improve the qualities of prisons. I mean, that was one of the things we were doing when we were rebuilding Afghanistan in the rule of law, was to contribute money to the judiciary, to the police, and to the corrections system. This was all part of the package of what we were doing with our presence in Afghanistan. So in that sense, this is a part of that. But I think when you refer to it, I haven't seen the case you're referring to in the European Human Rights Commission, but we were not in the position of sitting there saying, we know that they torture in the Afghan prisons, so we'll put in this agreement, but we're going to turn them over anyway. We didn't know that there was torture in the Afghan prison. We didn't have the experience of that. We had, I think, when we signed the agreement, we had every legitimate right to rely upon the word of the sovereign government of Afghanistan that they would live up to their obligations to Canada that they subscribed to in the agreement. If we had believed they weren't going to live up to them, we wouldn't have signed it with them. But we believed they would.
Thank you for that, Mr. Graham.
Mr. Graham, we'll go back to Mr. Deckert and Mr. Hahn Deckert. I can later.
Okay. Thank you, Mr. Chair. Mr. Graham, I accept at face value your statement that you believe that Canadian Armed Forces officials, Department of Foreign Affairs officials, your government officials were trying to do their best in the circumstances, in very difficult circumstances. I believe the same is true today. There are those, it's not my view, but there are those on the other side of the House and out there in the world, groups like Amnesty International, Human Rights Watch, and others, who say we could have done better. Perhaps that decision to transfer prisoners to the Afghan authorities rather than the U.S. authorities at Bagram was a bad one, or perhaps Canada should have built its own prison system and taken care of the prisoners itself. But I accept that everybody was doing their best. You entered into an agreement which, by your own admission, was flawed. We know it wasn't as good as the UK and Dutch agreements and perhaps other agreements that were entered into at the same agreement. And by your own admission, it was improved in 2007. If there are allegations of abuse today, do you, your government, your party, share any responsibility for that?
Well, I can't speak for today because I speak to you very happily as a private citizen.
Fair enough. But in your capacity as Minister of Defense and Minister of Foreign Affairs,
I am free from the allegations of this House of partisanship and other things. I can behave like a citizen like anybody else.
As a Canadian who was involved in the decision-making process, is it?
I can say that certainly.
How do you respond?
When I was minister, if you could go back, I'd go back. I could do a lot of things differently than I did. But, you know, perfection is the enemy of the good,
You
as
did
we
your
say.
best. You did your best.
And we did our best in the circumstances, in the light of the knowledge we had of the day.
Okay.
And that's the best you can do, because you can't. It's very difficult to foresee everything.
We're hearing conflicting views. Some DFATE officials say allegations of abuse were widely known, and they told all members of government, including your government, about that. Others say they weren't. Others say they don't think that there has been any abuse, there's any evidence of abuse. There seems to be a difference of opinion based on different views of policy that might have applied or should apply in this circumstance. How do you see these differing interpretations? I mean, how do you put that into context for us? What should we take from that?
My experience as a minister was we have, and in two ministries which have very large, very competent people, is there's always a diversity of views.
Right.
And within that group of officials, one works out what is the appropriate approach. And that's worked out at the level of those officials. And as a minister, you get the result of that. Right. You don't go downstairs at the bottom of the Foreign Affairs Department and walk around the halls and knock on doors and say, what do you think about this?
You were satisfied
You've
with
got a deputy minister who comes to you and says, this is the view of the department. And when I was foreign minister and when I was Minister of National Defense, I had a deputy minister and a chief of the defense staff and a legal advisor, all of whom said, this is the right thing to do. This has been coordinated with the other departments. This is our advice to you.
And you, sir,
and
yourself,
I believe that advice, and I think I was appropriate to do it.
Very well qualified as a minister, as a professor of international law, as an expert in international law, having served in those capacities and in government for many years. You were well qualified to accept that advice and understand the advice.
So that's for others to decide.
But I assume you would agree with that. Okay. I don't think I said that. I wasn't.
No, he wasn't there, but I'm thinking of some of your colleagues.
I have great respect for.
I'm glad that the honourable member brought that up. Actually, there were certain moments when nobody was saying that at all.
I think we're clear here.
You must like my evidence all of a sudden.
I've always admired you, sir, as an international lawyer, and I believe that you and all the other Canadian officials were doing the best they could in difficult circumstances. Right. And I believe that's the same is true today. And we're sitting here and we're hearing differing views now from people who were there at the time. Some say quite clearly you absolutely should have known, and others are saying there was no clear evidence, and what you did was the best in the circumstances. Right. And I'm just curious to know what you would do if you were in my shoes today in trying to interpret what Canada should have done back in 2005 and what it should be doing now.
I think I would do what the chairman, I believe, is doing, is trying to get the best evidence you can, and you're going to have to be the judges of what you believe and your knowledge of the political system and how it works and how you think would be the best in the interests of the country. And I'm confident the committee will its wisdom will come to that. But that's all I can suggest.
Mr. Dewar, please, 5 minutes.
Thank you, Chair. I just want to go back to wrap up the piece about General Hillier. So to get from you, you were informed by General Hillier when he had signed the agreement and it was done with General Wardak?
Yeah, no, probably not, the next day, but it certainly, it would have been informed.
Did you support him being delegated that responsibility?
I had no problem with it. No.
I'm saying that because I'm reading, because you mentioned the book. Yeah. In the book it says that you didn't support that, but your evidence today is saying that you did support delegating the authority to General Hillier? Because I'll just read it to you. The General signed the agreement for Canada even though Graham, you, had not delegated this responsibility to him. Hillier insisted the Department of Foreign Affairs had seen and approved the agreement at every stage and explained why he took the unusual step of signing the agreement and just saying what you had said. Wardak was a friend of mine. We got to know each other when I was commander of ISAF and the CDS in Kabul. Wardak asked if I could sign the agreement since he had great respect for me. I guess how do we square that?
Well, look, it seems to me there's two issues here. There's the underlying issue as to whether or not the fact that General Hillier signed the agreement somehow delegitimizes the agreement. If that's the point, that's a discussion. If it's just an attack on General Hillier for going and doing something. That's something completely different.
Not at all. No, I'm just talking about who should do what.
If I had to choose between General, if I'd been there, and somebody said, "What do you think?" I would have said, "Get the ambassador to sign it."
Okay.
But that would have been my opinion.
Well, I'm just going by what I read here.
But I wasn't there, and I didn't have General Wardak leaning over the table saying, "I'll sign it now if Hillier signs it, but I won't sign it." But I mean, you have to be in the negotiating room to know what's going on. I wasn't there.
Well, that's what
that's what we're
concern
told.
is. That's my concern. Is that
well, it's not my concern because I don't think it goes to the legitimacy of the agreement whatsoever.
Well, let me.
So it's a memorandum of understanding that was entered into in proper and due form between. But that has just as much effect by its signature in the way it was signed as if it had been signed by the ambassador. So that's not a concern to me.
But if the content of it is important, and what I'm seeing here is that the DND was kind of the lead in this agreement memorandum, and you admit, and it was during the debate, and it was already mentioned that it was Bill Blakey who brought up the process of which the Dutch had agreed to, and when that was brought forward by you or your staff to officials in the military, the Canadian Forces, they said that they pushed back to say, no, we don't need to put those aspects into our agreement. In other words, they said that we didn't have to follow the Dutch arrangement of monitoring.
Right. But we did follow the principle about no death penalty. We did take that from that agreement. That was very
right. But you didn't know about that until it was brought up in the House, correct?
No, that's correct. Mr. Blakey gave me the agreement.
So, what kind of advice were you getting? Who was it from?
I explained to the committee. I got the advice from the Major General Pitzel. Who
Do you think that advice was sufficient advice in light of what we know now?
You're asking me if General Pitzel could have given me the advice based on what we know now. He couldn't give me advice based on what we knew now. He gave advice based on what he knew then, which is the way in which we operated at that time as well. Nobody can foresee into the future. You can't ask General Pitzel to give me advice on the basis of what you know today.
But a member of the opposition was able to figure out what the Dutch were doing. Would it not, I don't think it's asking too much for our officials to have given you advice. This isn't, I'm not going after you, Mr. Graham.
No,
I'm asking you how, who's doing what. And from where I come from, it should be our folks looking at what's going on in theater, what is the best practices, and advising you as minister. I'm glad that they said we should take out the death penalty. Frankly, it's a no-brainer. But they should have looked at what the others were doing and advised you. But it wasn't in this agreement. In fact, they pushed back.
Well, they pushed back on the monitoring issue because they didn't believe it was appropriate in the circumstances, and that was
because they thought
that's what we didn't do. But as you know, subsequent government went into a monitoring agreement.
But they said that because the Afghans would push back, was why they didn't put it in.
Well, if you've done negotiating in contracts. It quite often is a good.
I've done it.
As you know, if you can't get the other guy to agree to it, that's a reason why it may not.
But when the other guys got in their agreement, I always get into mine.
Well, that's a fair point. That's a fair point.
Thank you.
Sure. I do have a question, Mr. Graham, and are you able to go a little bit past 5 o'clock?
I'm totally in the hands of the committee.
All right. Thank you. Thank you.
There's a more interesting hearing going across the hall.
I know there is. So
I don't think anybody in this. I don't think anybody in this room would rather be here than over there. So
I wouldn't think that. I think most of us would rather be here listening to you, Mr. Graham. I do have a copy of the book that you referenced earlier on, The Unexpected War, and in that book you actually get a fairly glowing. There's some nice testimonials about your abilities and what you wanted to accomplish at that time. But my question, I was here in the House at the time. In fact, I got into a little bit of a problem in one question period when I asked the defense minister, the former minister, about transferring prisoners to the Americans. There was some hesitancy. I found out from the Speaker, as a new member of Parliament at the time, I found out that I could say that he misled Parliament, but I couldn't say he intentionally misled Parliament. But that was the crux of the debate that day, and whether or not they were transferring. Now, in this book, it says, I'm just going to quote a couple of sentences, somewhat out of context, because I'm going to take different sentences from a couple of paragraphs. But it says, although Bill Graham had supported the Kandahar mission, he was deeply concerned about one issue. And then it goes in and it talks about the operatives, and it says, the issue of transferring Afghan prisoners. It also says that Mr. Graham was an international lawyer with strong interest in international humanitarian law. He had serious concerns about the transfer. All right? It says this, nevertheless, for Bill Graham, this issue was vital, and he would push his officials hard to get a resolution that satisfied his standards. My question is, it was highly politicized at that period of time, the Americans. We had one member of Parliament stamping on a doll of the President of the United States. We had others standing in the House slamming the Americans. It wasn't immediately after 2001, but it was 3 or 4 years after. And so my question is, you were coming into an election. Was there any consideration to the thought that, listen, we just cannot transfer to the Americans for political reasons? I mean, this book lays it out. Your concerns about what was happening at Guantanamo and what was happening in Cuba, but was it politics? Or was it indeed the potential for concerns of their rights at Guantanamo compared to an agreement with conditions that you absolutely felt would have the detainees in a safer position in Afghanistan?
Well, if I said there were no political considerations in this, I don't think you'd believe me, Mr. Chairman, and I don't think you should. I mean, of course, politics are a part of what motivates us that are in politics. So that's a given. But I think the balance of what we were trying to achieve here, as I said in my opening, was a recognition that we were acting in Afghanistan. The taking of prisoners by the United States had been going on for a long time. It was largely very much their war, if I can call it that. The meetings and discussions we had at NATO and with Mr. Karzai themselves were very much about legitimizing the international force in Afghanistan and taking it away from an exclusive American operation and becoming it a true international United Nations authorized operation. And that was the whole thrust of why we agreed to go with the Dutch and the British to go down to the south. That was the whole of what we were trying to achieve. That was the geopolitical, if you like, thrust of what we were doing. And it was long discussed in NATO and everything else. This prisoner issue was one very important subset in that. And that prisoner issue then, when I say that we looked at it and said it is preferable to turn the prisoners over to the Afghans with appropriate safeguards than to the United States, was an overall consideration of the political, geopolitical issues at stake and the nature of the legitimacy in the country of Afghanistan and legitimacy in the eyes of the Canadian public as well. Every one of those factors played a role, and every one of them factored into our decision. And I think we made, frankly, the same decision would be made today if everybody in this room was sitting there faced with exactly those same circumstances. That's only I could say.
And you also would agree, not to put words in your mouth, that the additional transfer agreement later on that included monitoring of prisoners was a good addition?
It certainly was an addition, which
you're up.
It certainly created an additional pressure, if you like, on the government of Afghanistan and gave Canadians more of an authority to do it. So I don't disagree with it was an improvement on the agreement. I said the agreement was not perfect, and I accept the fact that it was capable of improvement. There may be other improvements in the light of today that maybe we should be making other improvements to the agreement. Life is a growing evolution, so maybe we should be making some other improvements, Mr. Chairman. So I would be happy to concede that lots of improvements could be made to the agreement. That would be my, so I accept your statement. But I would say, what I also said, sir, and I'm sincere about this, that a lot depends on how it's applied. The day after you signed your new monitoring agreement, all these problems didn't go away, if I believe what's being read in the press. And the British had a monitoring thing that was in force long before ours, And if you read what's going on in the British House of Commons today, the same debate's taking place there that's taking place here, with or without the monitoring. So it's not the monitoring in and of itself, it's how it's applied in the circumstances that also has to be taken into account. This would be my respectful submission.
Thank you. Monsieur Beauchamp?
Oui, tantôt, Monsieur Graham.
Mr. Graham, earlier you told me that there were no transfers of prisoners before 2005, but I remember having seen a photo in the Globe and Mail of the JTF-2 forces, and they appear to be transferring prisoners to U.S. authorities. So that's my first question. Please correct me if I'm wrong. And my second question is, when the BC Civil Liberties Association and Amnesty International brought the federal government to court, it was revealed that in 2002 and 2006, there had been over 40 detainees who had been captured by the Canadian forces, which seems to somewhat contradict your testimony, unless you tell me that those 40 prisoners remained under the authority of the Canadian forces. So, were there transfers before the agreement, yes or no? Were there agreements with the U.S. authorities? And what did you do with the prisoners who you did not transfer? Did you keep them under the authority of the Canadian government in the Kabul prison? First, when I said that there was no transfer of prisoners, I didn't say there were never any transfers of prisoners, because we know what happened with Mr. Eggleton and the transfer with the JTF-2 in 2002. So everyone knows about that. So that I'm not denying. And I believe, although I don't have any personal knowledge of this on a case-by-case basis, that there were certain other transfers, occasional transfers, in the interim. When we were in Kabul, for example, when ISAF was in Kabul, I believe that there were a few prisoners taken at the time, and I imagine, because I was not Minister of Defense at the time, that they were transferred to the U.S. authorities, because that was the practice at the time before the agreement was signed. But when you talk about 2006, I stepped down from my position on January 30th, 2006. So if the 40 prisoners were captured between January 1st and January 15th, then I'm guilty. But I strongly doubt that that was the case. It was after the beginning of the activities in May when we began our activities in Kandahar. That is what I presume, but I don't have any personal knowledge of it. Thank you.
Graham,
this is getting to be a little bit like Chinese water torture.
Well, you're doing a very good job.
We won't transfer you. Am I have any prisoners' rights here myself?
We won't transfer you anywhere.
Okay.
You were never one of my professors, so
Right. Yeah, you can say
we don't have to. Yeah, and I thought at one point you said that you were defeated in 2006, and my recollection was that you stepped down, and I'm not so sure about your replacement, but
I'm very proud of my replacement.
But he's not a
great
bad
memory.
guy. He's not a bad guy. Anyways, what I would like to ask you, though, is that there's been a great deal of discussion both in here and in the House about redacted documents. When you were the minister, did you do the redaction of the documents yourself?
No. The documents are... Sometimes I would receive very sensitive documents, for example, that would be classified, and unless I said, look, I've got to see that, they would be redacted. So they'd be redacted at the level of the security officials, and I don't recall ever challenging it, because I don't think I ever had a case where I had to say, look, I want to know what the actual circumstances of this are.
But they
usually dealt with anything that was redacted was usually of an operational nature, and that therefore knowledge of the operation would have been inimical to national security. So obviously as a minister, one has a right to it, the information, and I'm sure if one had insisted, but the circumstances weren't appropriate at that particular time.
So I think if I understand you correctly, what you're saying is that redaction was done by officials when you were the minister is exactly what we would expect, and you wouldn't expect it to be any different today?
I have no idea what the practice is today.
But it's not directed by the minister. It's done by officials who do it because they follow set policy or procedures.
Yes, I'm assuming redaction is done by officials in the department and not by ministerial staff acting under the instructions of the minister. If that were done, I would say that it would not be in any way conformity with what was done or practiced when we were there. Anything that was redacted was done by the officials.
Wrap up.
Thank you, Mr. Chair. You know, we've taken about 12 minutes to talk about General Hillier signing the document. Can I ask you one real simple question, Mr. Graham? Is there any doubt that the 2005 agreement was an agreement between the Government of Canada and the Government of Afghanistan?
No, but I have to say that, you know, the lawyers are clear that it was not, it is more an agreement in the form of a memorandum of understanding than a binding legal treaty of that nature.
Absolutely.
It was not intended to be that, and I don't think that any of the other agreements that were entered into at that level of international law. So
but it was a government to government.
It was a government to government.
Thank you.
As I believe I tried to.
Yeah, you did, and you were doing a good job. Even Andrea Presso of Human Rights Watch said in her response or testimony a week or so ago that there are reports of recently transferred detainees that, you know, conditions had improved, and I think that's the story we're hearing. You know, the 2005 agreement was in good faith, turned out to be not what we thought it was. There were changes made, things improved. I mean, is it fair to say, and you used the expression a minute ago about the balance of what we are trying to achieve, that on the balance of what we were trying to achieve, when I say we, I mean Canada, under either, you know, your government or under this government, that the balance of what we are trying to achieve is to make things better with whichever institution we're dealing with in Afghanistan, whether it's the Afghan National Army, the police, the prison system, the judicial system, whatever, and that is, you know, the basis of everything that we are trying to achieve on balance, knowing that some is going to work better than others, and they're going to stumble, and we're going to pick them up, and we're going to show them how they could have done better, as your government tried to do, as our government's tried to do, as the Canadian Forces and DFATE and CEAD and everybody else has tried to do all along.
Yes, sir.
So,
I think that's a fair statement, yes.
And that nobody is guilty of anything other than doing the very best they could, and I'm going to repeat myself, the very best they could under very difficult circumstances in a very difficult place with very difficult people with the information they had available at the time.
That's drawing a very long bow.
Well, you answered in the affirmative the last time, so I was just giving you a chance to do it again.
I want to thank you very much, Mr. Graham, for attending here today. We have asked a number of former ministers to attend, and you're the first of, I hope, a number, but you are the only one so far that has responded with the affirmative, and so we do appreciate that. We wish you all the best. We thank you for your insight, both as a parliamentarian, a distinguished parliamentarian, and as a defense minister, and it was good to see you again.
Well,
we're going to suspend for 1 minute. We're going to move in camera for the final 15 minutes. So I would ask all those others to make their exit. We are allowed one per member of Parliament, and one from the Whip's office. So if everyone else could exit for approximately 10 or 15 minutes, and then we will reconvene in camera. Thank you.